So welcome back after the break. We are very fortunate to have our next speaker is Beth Barrett Bloom, who is a partner at Frank, Fried, Subit, and Thomas. Beth is a former law clerk to Federal Judge Deborah Batts of the U.S. District Court for the Southern District of New York. She, before ever entering private practice, was involved with the ACLU of Washington, the National Gay and Lesbian Task Force, is a co-founder and past president of the Q Law Bar Association, and is also a graduate of the Washington State Bar Leadership Institute. She's been a trustee for the King County Bar Association, is pretty much involved in every professional civic organization that you can imagine that's of any import in Washington, and is also a rising star perennially for the Washington Law and Politics magazine. She's an associate professor at the Seattle University School of Law and is the author of the Washington State Association for Justice Employment Law Desk book. So please welcome Beth Bloom.
Thank you. That was a nice introduction. I just want to say first, just on a personal note, I was one of the founders of Q Law in 2005, and it was really just the idea, wouldn't it be great if we could bring gay, lesbian, bisexual, and transgender lawyers together? I wonder what they could do. But we just felt if we built it, they would come and they would do great things. And I think that today, I just want to take a minute to just step back and reflect. Today is a really special day because what it means is that it really is true that if you bring together caring, committed lawyers, we can together do amazing things, such as serving the legal interests and legal needs of our community and expanding out of the bubble that is Seattle. And so I am just so pleased that when I was asked to be here and speak, it was a personal thrill to hear that Tacoma is going to be developing its clinic. I understand that there are oodles of volunteers. I heard there's 25 volunteers who want to be involved in this exciting new endeavor, and that there is already a waiting list of interested folks who want to come and get advice from you and who are struggling with how to pursue their legal interests in a world that is still very hostile, as you know, to the interests of our community. So I just really want to say kudos to you. And thank you for your commitment as we go forward with this exciting project. All right, enough of that. Let me talk about employment law. That's what I'm going to talk about. I do have a day job, Dominique, beyond being involved in a lot of professional associations, and that is that I am an employment lawyer. That's what I do full-time. I represent employees exclusively, and I have a particular interest in serving people who have experienced discrimination because of their sexual orientation, and also people who have experienced discrimination because of their gender identity and expression. And I'm going to spend quite a bit of time talking about the employment challenges in that arena. Let me just start by saying you are going to see employment law cases if you work at the clinic for any period of time. It is not as common as some of the issues. It's not as common as family law. It's not as common as name change issues, but it's right up there in the hierarchy. So if you've been snoozing, this is the time to snap to, because you can do a lot of things to help people who are facing employment issues. And sometimes that's not necessarily going to be giving them the advice that they want to hear. Sometimes you may just be letting them down easy and managing their expectations in terms of what is unfair and distinguishing that from what is illegal. And that's a key issue, because the truth is the ability to be unfair, even inhumane to some degree, is an employer's prerogative in many areas. What we're going to be focusing on is what happens if the reason that a person is being discriminated against is because of their sexual orientation or because of their gender identity. And how do you prove that? So I have about 45 minutes to talk. I am going to encourage people from the audience to raise your hand and ask questions as we go. I will then repeat the question as I've been told to do. I will look into the camera when I do that. I have, my presentation really have three parts. First, I want to talk about who is protected. Then, what are they protected from? And then finally, how can we help those folks? All right. So with that, let's kind of dive into it. Okay. So in 2006, the Washington Law Against Discrimination was passed to be amended to include sexual orientation and gender identity. And so this is the big state law for Washington State, the Washington Law Against Discrimination. That law is a comprehensive law. It includes employment protections. It also includes housing protections, housing discrimination, insurance protections. They're all housed within this area of practice. In this statute, the federal corollary that I'm sure you've all heard of is Title VII. And in many ways, Washington law and federal law are identical, but there are some ways in which they're different, and I'll point those out as we go through. Okay, so what does the Washington Law Against Discrimination have to say when it comes to our community? So first, the law identifies who is protected, all right? And it defines sexual orientation as essentially having a sexual orientation. And since all people have a sexual orientation, all people are protected under the Washington Law Against Discrimination. So far so good. Everybody's protected. So that includes gay people. You're probably going to see some gay and lesbian people. They are protected. It also includes bisexual folks, and heterosexuals also protected. And that simply means, in essence, one's sexual orientation should not be a substantial consideration in any kind of employment decision. Should not be a consideration in pay, should not be in consideration in hiring or firing, it should not be a consideration in discipline, etc. In addition to everybody being protected on the basis of their sexual orientation, everybody is also protected on the basis of their gender identity or expression. And that doesn't just include people who identify as transgender. It includes a butch woman. It includes someone who identifies as neither male or female, isn't transing anywhere, but simply is genderqueer. And the notion here is that a person should not be evaluated for employment purposes based on how they represent themselves in terms of their image, their physical appearance, how they behave, how they express. It doesn't matter if you express yourself in a way that would be recognizably male or recognizably female. It doesn't matter what a doctor said you were when you were born in that instant. You can be and express yourself however you want to express yourself under the gender continuum and be protected under Washington state law. This is actually a big deal because we are one of the few states that has a gender expression or identity protection that is as broad as this is. And I will tell you, in my practice, even though the trans community is a smaller community than the gay and lesbian community, I see a lot more trans cases than I do gay or lesbian discrimination. And I think that is because as a society, I think we're more comfortable at this point with the idea of sexual orientation and fluidity around sexual orientation. Human beings are really invested in the gender expression of other human beings. I don't know exactly why that is, but it seems to be a social phenomenon. There's something about your gender expression as female that threatens me or threatens my gender expression as female. And there seems to be there's some way in which people are not quite ready to say your gender expression or identity is irrelevant to my gender expression or identity. Whereas you have a husband and you're male, and I have a husband and I'm female, people seem just a hair's more comfortable with that. But people still really get up into other people's business when it comes to gender identity and expression. And as a result of that, we see a lot of claims related to trans discrimination in the workplace. There isn't, however, currently unless it happened in the last month while I was focused on something else, there isn't currently any published litigation in Washington State on transgender legal issues in employment. I'm sure it's coming, but it just hasn't gotten out there yet. So stay tuned. There are federal cases, but there isn't a state case. Any questions just about what I've said in terms of what is gender expression and identity, or what is sexual orientation protection under the statute? I'm seeing a group of smiling faces, so I'm going to move on, which is nice. Let me also add, not new to the statute, but worth remembering, is that a person's HIV status, whether it's HIV positive or HIV negative, is also protected under the statute. So if a person came in and said that they felt that they were being discriminated against because of the perception that they were HIV positive, that is also an illegal basis under which to make an employment decision. All right. I said who is protected was going to be my first subject. Now I'm on to from what are we protected? So we're protected from discrimination on the basis of sexual orientation or gender identity. That comes up in the scenarios that I've listed. To borrow David's term, this is not a comprehensive list of all of the ways in which one could be discriminated against in the workplace, but it's a pretty good list. So you'll see cases where someone says, I wasn't hired because I'm transgender, and I'm detectively so. I mean, I wasn't passing as female, or I wasn't passing as male. I have a current case where a trans woman in the interview was repeatedly called he by the interview panel, and she kept correcting and saying, no, actually I'm she, and they kept saying, okay, well, he this and he that, and then she later had a job reference, and she had worked, and her coworker knew her as male and referred to her by her former name and her former male name, and talked also about her gender transition. So her gender identity and expression is very much in the air in terms of her job application, and she didn't call me because she got the job. So, and in fact, in statistically speaking, the transgender community has an unemployment rate that is double that of the cisgendered community, and that is directly related to the difficulty of entry, how difficult it is to get in the door if you don't pass. And so hiring is definitely one of the areas that you will see at some point in the work of the clinic. An obvious one is firing. You cannot fire somebody because they're gay or because they transition on the job. That's another common scenario that you'll see. You can't put the gay folks in the bad offices and put the straight folks in the good offices. You can't pay the trans people less for the same work as you pay the non-trans folks. Those are the kinds of decisions that cannot be based on sexual orientation or gender identity. I think what gets tricky is most employers are sophisticated enough to give a non-discriminatory reason for their decision making. So a common one is, I didn't fire this person because of their sexual orientation. I fired them because they were late in completing this report, or they couldn't get along with their coworkers, and here's an example. I'll talk a little bit about how to disprove that, but just staying kind of high level, these are the kinds of discriminations that you cannot be forced to endure. Related to the hiring decision, the failure to hire type of claim, you should know that there is a Washington Administrative Code, WAC, on what you can and cannot ask in a job interview. And especially for trans clients, this is a helpful thing to know. The WAC says that it is per se discrimination to make a statement in a job interview or in an advertisement for a job that you are going to prefer anyone based on any of a series of protected classifications, which includes sex, marital status, sexual orientation, HIV status, etc. I have a case right now this is not a sexual orientation case, but I have a case right now of a job applicant who was asked, how is it that you're going to be able to work here when you're clearly in your late 50s and your boss is in her 30s? Do you really think you could handle taking direction from someone who's 15 years younger than you? Okay, that's illegal, just flat out. Okay, so that's a per se violation. That would also apply to somebody who is having an expression, being told that something about their sexual orientation or gender identity is problematic and being asked about that. So it is a question that I get, certainly especially for trans folks, is, well, if they're not allowed to ask, can I tell them? Should I tell them? And the short answer to that question is, it depends, right? I mean, that's kind of the lawyer answer. In general, I think I have a lot of clients, especially trans women, who are they look fantastic. They pass in any situation, and they're at a stage in their transition where keeping their transgender identity private is important to them, and they don't need to disclose their trans identity because it doesn't come up. And so in that situation, I don't think it needs to be disclosed. On the other hand, if you've just transitioned, you know based on your interactions with the coffee person and the gas station guy that there's a lot of reaction to your gender expression, it might be worth raising it and kind of identifying it in the room in that situation. So it depends. Does anybody have any kind of contributions to that? People that they know that have dealt with whether trans identity is private or not private? Getting a lot of smiles, again, a lot of smiles. But no one has a story on that. Okay. I mean, I think it's a tricky situation. I mean, I will tell you this, in the disability community, disabled employers are told not to disclose their disability during the job interview process. And the idea is because if the employer doesn't know about your disability, then they can't discriminate against you on the basis of that disability. And I think the issue here is if your potential employer is definitely going to know about your gender identity just by looking at you, then to some degree the cat's out of the bag, and you might address that right there on the spot. Okay. Another thing that you're protected against being asked about your gender identity and expression or your sexual orientation in a job interview. That's what you're protected against. And the idea of this, it's not just kind of gift wrapping or kind of just a shallow sort of notion. I mean, it's supposed to get at the larger issue, of course, which is that you're not supposed to be discriminated against in the decision to hire. And so this is hand in hand with not being discriminated against, is not being asked discriminatory questions that would help a discriminator decide whether or not to discriminate against you. So that's this law. The next thing that you're protected from is that you cannot be harassed because of your sexual orientation or your gender identity or expression. Some of you might be a little too young to remember the birthplace, the popular birthplace of hostile work environment as an idea in American culture. It comes out of the Anita Hill, Clarence Thomas confirmation hearings when it was revealed that Clarence Thomas was a lech. Say what you will about his political and legal opinions, but his personal conduct is also reprehensible. And Anita Hill was brave enough to come forward and talk about the ways in which he was just disgusting from a sexual position, and how he used his power and authority to be sexually abusive towards her in the workplace. And that launched this idea, which now everyone has heard of, which is hostile work environment. The problem is that not all hostile work environments are on the same footing. Lots of people, I mean, I think if I just by show of hands, how many people feel that they've been treated hostilely, just dictionary definition, in the workplace? Everyone in the room is raising their hand that they have been treated hostilely in the workplace. Well, you can imagine what a nightmare it would be if each and every one of you had legal claims resulting from the hostility that you faced in the workplace. There is a notion that in the American workforce, there's going to be a certain amount of hostility. There's power dynamics. You've got bosses, you've got supervisor, you've got line workers. There's subjectivity. You thought you did a great job. Your boss thought you did a crappy job. You know, there's deadlines. Some of them are met, some of them are missed. You know, there's personal hygiene. There's all kinds of reasons why someone might, you stole my coffee cup. I mean, it's endless, right? I mean, most of us who are in the workforce, we spend more time with our coworkers than we do with our own kids, right? And so naturally, tensions are going to arise. Well, that is not a hostile work environment. And so this is, I think, one of the most critical things that you can do as a volunteer is to understand what is the difference between an illegal hostile work environment and a crappy but perfectly legal hostile work environment. And this little slide kind of explains that. All right. So the key difference between a hostile work environment that's illegal and one that is legal is the motivation of the person who's doing the harassing. Okay? The harassment has to be because of the person's sexual orientation, gender identity, or expression. How can you possibly tell if somebody is harassing you because of your sexual orientation? Sometimes you don't know. I mean, you don't always necessarily know. But some of the telltale signs are they use words that are hate words that are associated with sexual orientation. You get called a faggot, or you get called, I think the last time I did this presentation, I introduced the term clam bumper. Look it up, it's a word. If you're called words, if you're called harassing, hateful words that are based on your sexual orientation, that is a clue that you might have an illegal hostile work environment claim. I don't know if everyone's recovered from that. Let me just give them a second. Are we good? Are we good, ladies? Okay. That's what makes my job fun, is that I get to learn these terms. That and my kid, he teaches me these terms as well. So if you are being harassed in the workplace and the person who's doing the harassing is using words that sound like hate words that are making it clear that your sexual orientation is on the harasser's mind, that's a sign that you might be moving out of the world of legal hostile work environment and into the world of illegal hostile work environment. Same would be true for gender identity or expression. There you might find that you've transitioned on the job, you've been living full-time as a man on the job, using the men's room, you've changed your name to a man's name, and yet there's a particular colleague who in meetings is perpetually calling you she this, her this, and does it, and you remind them and you say, I know this is new for you, but just to remind you, I'm living as a man now, and if you could use male pronouns, and nevertheless, she, her, how is it doing, things like that. Those are all indications that your gender identity or expression is on that person's mind, right? And there's a point that's sometimes difficult to pinpoint, but there's a point where use of prepositions moves from just an innocent mistake. I mean, just the other day, I used the wrong pronoun with someone who's a world-renowned trans lawyer, and I called him a her. So it wasn't that I did it from a place of hostility, but it happens, and this is my practice area. So I think that there's going to be mistakes that are made, but I think you can tell when someone is purposely using pronouns in a way that's aggressive. And so that would be an example, potentially, of crossing the line between just a hostile work environment and one that is because of gender identity and expression. Are there questions about because of gender identity or because of sexual orientation? Or Laura, do you want to weigh in on this one? Do you agree with me that this is a big difference, a critical line in the sand?
I do. So yes, we've had managers that get in trouble for being bad managers because they create a hostile work environment, but not, little H, little E. And I get that all the time. That it's a hostile work environment. It's like, well, is it because of some protected class that you're in, or is it because you have a jerk for a boss?
Right. I'm just going to repeat what you said just for the camera. That was Laura Wurst. She's a former assistant attorney general for the state of Washington, and she said that oftentimes you'll have a manager who's hostile or is just a mean person. But that doesn't necessarily mean that they are creating a hostile work environment on the basis of membership in a protected class. So one of the things that you can do as a clinic volunteer when someone comes to you and says, I think I'm experiencing a hostile work environment, and the very number one question out of your mouth should be, well, why do you think this person is harassing you? And then just shut up and have them tell you what the reason is. And you're going to hear all kinds of reasons. He just doesn't like me. I have no idea why he's harassing me. He thinks I'm not good at my job. His friend has my job and he wants to replace his friend with me. I mean, there's any host of reasons why someone might be a jerk in the workplace that's not related to sexual orientation or gender identity and expression. On the other hand, if they say, well, he's calling me hate language, he's refusing to use my preferred pronouns, he's, hissing at me under my breath when he sees me in the men's bathroom, these would all be indications that perhaps there's something else on the mind. One of the things that makes employment law both interesting, fascinating, I mean, really, truly, if you ever thought about going into employment law, it's really a very interesting area of law because it's this nice combination of sociology and the intellectual stimulation of an area of law that is developing and growing all the time. But I do spend a lot of my time just kind of being like a Sherlock Holmes of the mind of hatred, because I am trying to get into the mind of someone who I don't know, I've never met, I'm just getting one side of the story, but I'm trying to look for clues that this person is evidencing bias. And sometimes not even bias that they realize they are expressing. I mean, I don't know, has anybody heard about the implicit bias studies? A couple people? Okay, so the implicit bias studies are studies that are done out of the University of Washington and Harvard. And what they did is they have a series of slides that they show you in a time setting, and you have to associate the picture that you see with a choice of words. And they'll show you pictures, for instance, of a person who is Asian and a person who you would think is like Eastern European, and then the word will be, surgeon. And you have to decide in an instant which picture goes with that word. And what they found is that we all have these shortcuts, these mental shortcuts that we take in our minds that allow us to filter all of the information that we're inundated with every day, always, but that they will tend to show a stereotypical way of thinking. And if you think about a stereotype, what is a stereotype but a shortcut? It's a way of looking at someone and thinking, oh, I think this person is this, I think this person is that. And that is a challenge in employment because the idea of employment is it's intentional discrimination, but it also can be unintentional, even unknowing discrimination. I mean, we're not necessarily talking about people who are bad people, who are evil people. We're talking about people who are human, who are just like us, who are trying to do the best that they can, but may not be even aware of some of the underlying biases that they experience. So back to the Sherlock Holmes of the mind, what your job is really working with these volunteers is to try to help them, maybe for the first time, get into the mind of the person who is harassing them and try to figure out what is the motive and what are the pieces of direct and circumstantial evidence that would indicate that there's something illegal happening in the circumstance. There are some other criteria, as you can see on this slide, that make it also challenging to prove hostile work environment claims. The conduct has to be unwelcome. It has to be severe or pervasive. And it has to be so serious that a reasonable person in the situation would feel that it was interfering with their ability to do their job. So that is to say, not all illegally motivated harassment is necessarily illegal hostile work environment claim. You have to get into this higher standard, which is that it has to be because of your protected class membership, and that it also has to be sufficiently serious and severe. One of the most important things you can do with a volunteer, once you've determined whether or not someone is being harassed in the workplace because of their gender identity or their sexual orientation, is to encourage them to go to HR. And the reason for that is that the human resources departments of these corporations have a legal obligation to investigate and to promptly stop harassment that occurs. And under various legal standards, that the failure of an employee to go to HR and complain can be an affirmative defense. Because and I'm going to get to you in just a second, in a sexual harassment lawsuit, you're not suing the harasser necessarily, you're suing the company who employs that harasser. And so that means there's an issue of imputed liability. And in order for the lawyer to be on the hook, the lawyer, at least under federal law, the employer has to know of the harassment and have failed to stop it before you can sue them. There was a question. Go ahead, Julie.
And if it's HR is the problem, or HR is ignoring the issue, or says, oh, sure, I'll take care of that, doesn't write it down, doesn't put it in the employee's notes or anything like that.
What to do in that case? So the question was, what if you go to HR and you bring your hostile work environment claim and they don't take it seriously or they don't do anything about it? A piece of advice is, and this comes from my experience as a trial lawyer, if it's not on paper, it didn't happen. That's just like a basic truth of evidence. So I think that an employee who's smart is going to keep a diary, is going to write down, went to HR, spoke to so-and-so, this is what happened. I usually ask my clients when I'm kind of behind the scenes coaching, I'll ask them to send a friendly follow-up email confirming the contents of our conversation. And the fact that you sent that email and you didn't get I never met with you, I don't know what you're talking about, that's not what I said, in response is an indication of assent that the person receiving the email agrees that that's the gist of what happened. But that is how you can prevail in a hostile work environment claim, is just exactly what you said, Julie. You went to HR, you tried to get it fixed, the behavior continued, it was severe and pervasive, it was unwelcome, it was because of your sexual orientation. That's a bona fide legal claim at that point, right? I mean, the notion of these employment laws is that we want to give employers the right as a first responder, sort of to take their emergency personnel analogy. We want the employer to have an opportunity to fix it, and then if they don't fix it, at that point the courts would want to get involved. Does that make sense? This is not something we're protected from, but rather something we have a right to, and that is a right to a reasonable accommodation. Why is this slide in here if we're here talking about gender identity and sexual orientation? I think that there is a legal right for a transgender woman who has a diagnosis, a gender, now they've just changed the name. It's not gender dysphoria anymore. What is it? I need somebody's help.
Is it gender spectrum? It's spectrum now.
Gender spectrum, okay. Used to be gender dysphoria, we think now it's gender spectrum. You'll Google it at home and you'll figure out what the right term is. I apologize that I didn't study that. Just changed in the DSM-5, so you'll excuse my not having kept up. Anyway, I think, and you heard it here first, leading mind in the Washington employment law world, I think there is a legal right to be accommodated in the workplace because you are transgender. And it is the case that is not true under federal law. There's actually an exception under Title VII, and exception under the ADA, the Americans with Disabilities Act, that says transsexualism is not a disability and therefore not entitled to protection. But under state law, I think you have a right to a reasonable accommodation, which means you have a right to have somebody help you figure out how to change your name, how to change your email, how to announce to your coworkers that you need to use a different restroom, get involved if there are conflicts that arise. I think that's something that you're entitled to. And so I've added this slide to say, if you are transgender and you need help from your employer to live effectively at work, consistent with your gender identity, that the employer has an obligation to help you. Thus, the reasonable accommodation. Last is the axe. Last is retaliation. So the last thing that you're protected from under the discrimination laws is you have a right to exercise your right to be free of discrimination and not to be retaliated against because you did that. You have the right not to be retaliated against because you brought forward in good faith a complaint that you're being harassed because of your sexual orientation. You have a right not to suffer because you asked for a reasonable accommodation. You have a right not to be denied another job opportunity because you complained that you didn't get a promotion because of your gender expression. That's the notion of retaliation. It's not that you're being treated differently because of your membership in a protected class. It's retaliation because you engaged in protected activity. And there, you just have to have believed in good faith that you suffered discrimination. You don't necessarily have to be right. So oftentimes what happens, let me see if I can think of an example. Trying to think of a good example. Sometimes people don't have strong claims that are discrimination claims or harassment claims, but they go to HR and they write a statement that says, I think I got this negative performance review because my boss is discriminating against me on the basis of my sexual orientation. And the employer does an investigation, determines you were wrong, that the performance review had nothing to do with your sexual orientation, rather it was because of, you missed this deadline or whatever. In the process of doing that investigation, your boss learns that you complained to HR saying that you thought that they were discriminating against you, and that fact that you complained pisses your boss off something fierce. He is outraged. She can't believe that you would think such a thing of her. Her feelings are hurt. And she thinks, oh yeah, well, now I'm really going to get you. And therefore begins to push you out of the company. That is illegal. And to be honest, it's easier to prove a retaliation claim than a discrimination claim. And the reason for that is because I think people understand that retaliation is a human instinct. When anyone gets hit in the face, their first instinct is to hit back. And people get that and juries get that. And so one of the things that you can do as a volunteer is to help encourage employees to go forward and to make these complaints. I'm not talking about bogus complaints. I'm talking about good faith complaints. And the reason for that is that It is a way of putting, I talk about it as kind of a retaliation umbrella. If you have engaged in legally protected activity and then followed it up, of course, with a nice, friendly confirmation email, then you have done something that is legally protected and you can't be retaliated against for it. And that can be very helpful. What actually happens is a lot of people are really afraid to go to HR, or they don't have an HR and they're afraid to go to their boss because they think that it's going to make things worse if they complain, when in fact, legally speaking, they'd be in a better position if they had actually complained and made documentation of that protected activity. So those are the kinds of issues that people are protected again from, just to review: discrimination, pre-employment inquiries, harassment, reasonable accommodation, and retaliation. All right. Any questions about those types of illegal activity? Dominique.
So I did look up what it used to be gender identity disorder. It's now the correct term is gender dysphoria.
For the camera. It used to be gender identity disorder, disorder being a pejorative term. Now it is gender dysphoria. So if you rewind this tape, you will hear that I actually did use the right term, and then I incorrectly corrected myself, just for the record. Let's talk about helping victims of discrimination. What can you do? What are some of the things that you can do in your role as a volunteer to help victims of discrimination and retaliation? I'm going to just give you some high-level information. First of all, there's an organization called the Human Rights Commission. It is based in Olympia. It has some local offices as well. It is the state agency that investigates discrimination claims. You do not have to file a complaint with the Washington Human Rights Commission in order to pursue a claim in court, but you can. And it can be helpful because they do investigations and they can reach what's called a reasonable cause finding. And so a lot of the times I will have people make a complaint with the Human Rights Commission. The other option is the Equal Employment Opportunity Commission, which is the feds. They also now will process complaints for gender expression discrimination, and also they're starting to process sexual orientation claims as well. And what that means is that it opens up the ability to have federal claims, and that is positive. There are strict deadlines. The deadline to file with the EEOC is 300 days from the last discriminatory event, so that's a little less than a year that you have. And to file with the Human Rights Commission is 6 months. So if you're going to file a charge, you have to do it pretty quickly, but it can be a good positive thing to do. It also indicates to the employer that you're pretty serious about pursuing your legal claims. David?
Filing complaints. If you file a complaint with the Washington State Human Rights Commission for employment discrimination, do you have to do a separate one with the EEOC as well too if you want to preserve a federal complaint?
The question was, do you have to file with both the EEOC and the Washington Human Rights Commission? And the answer is no. They have cross-filing for both. So if you file with the Human Rights Commission, you are automatically filed with the EEOC and vice versa. And to that regard, the EEOC is better because you have 300 days instead of 180 days. Okay, that's what you can do in terms of agency filings. So in my remaining minutes, I want to talk about the materials that you have and also talk about what you can do, just practically speaking, to help people that come in. My advice to you is that you distinguish, brainstorm, preserve, advise, and direct the client to get more help. Let's start with directing the client to get more help. Unlike what David was talking about earlier in family law, where it's very difficult to get an attorney who will work on your case pro bono, you can get an employment attorney who will take your case without charge. The reason for that is prevailing party fees. Under both state law and federal law, if you prevail in proving that you were the victim of illegal discrimination in the workplace, you can recover attorney's fees. And what that means is there's a whole bunch of employment attorneys out there who take contingency cases. They only take strong cases, and they're going to be pretty distinguishing about that. But a strong employment case is something where a referral to a good lawyer is a good idea, because this is an area of law where not only are the facts complicated, but the law changes almost every day, and having good, competent legal representation is valuable. So, how do you figure out if this is a case where you might want to make a referral, or how do you help somebody develop their situation into a claim where a lawyer might be interested? So the first, we've kind of already been talking about, which is trying to distinguish between harassment or treatment that's unkind and treatment that is because of illegal discrimination. So there the question is, what is the motive of the person who's doing this conduct? How do you know that? Why do you think that? That's trying to distinguish between and determine the motive of the employee. The next is that there's a lot of opportunity to brainstorm. Sometimes people are just coming to you and they're frustrated and they don't know what to do next. And your job is really to just sit and to listen and try to help them figure out how they can help themselves. I mean, maybe that's going to HR, maybe that's helping them write a thoughtful email in response to something. It's difficult to say based on the situation, but sometimes people are just looking for routine help, the kind of help that a third party, just an objective person, can give. I mean, maybe your advice is you better get to work on time. I mean, okay, that might be the advice that you would give under the circumstances. So that's brainstorming. The next piece that I talked a little bit about, but that's just either creating or preserving evidence. Let's take a hostile work environment claim as an example. In order to prove that you've suffered pervasive harassment, you better have a diary or a log or a calendar or something that records each and everything that this person did to you and said to you and how you responded and that you went to HR and that it continued. And so that's an important piece of advice that most people are not thinking of. They're not thinking that anything other than their own word is needed. And those of you who are trial lawyers know that you need a lot more than just the testimony of the witness and of the plaintiff in particular, because that person's going to be considered not credible and biased. So a diary that they keep, I usually tell people to keep it at home or keep it on their phones in some place that if for whatever reason you were suddenly given a box and told to get out within the next hour, you would still have that material, that you would have your evidence. Another we've talked about is the very helpful follow-up email. Those follow-up emails can be very valuable. And it is okay for you to send an email to HR and blind copy yourself on your home email account. That is okay. You cannot take company materials out of the office and put them on your home computer, but an email that you've sent to HR is perfectly acceptable for you to keep a copy. So what you're doing is you're trying to record with documentation your miserable experience so that you can recreate it later down the line with a lawyer who can see that you've been conscientious, that you've been objective, that you've recorded this, that there are some objective criteria that support your claim. I think that's also advising. The last thing I want to talk about is proving it. How do you prove that you have been discriminated against because of sexual orientation or gender identity and expression? We've talked about writing everything down. We've talked a little bit about direct evidence. That would be when the person doing the discriminating uses words that clearly indicate that your sexual orientation is at the forefront of their minds. Another is circumstantial evidence. That's a tricky one. I mean, circumstantial evidence is something that you can help these clients think about. Circumstantial evidence might be that, okay, yes, your report was late, but so was Sally's, and so was Sue's, and so was John's, and they didn't get suspended for a week. And what's the difference? You're all working for the same person, but rules are being enforced against you more harshly than they are against other people. Well, that's circumstantial evidence that you're being treated differently, and that may be relevant. Another example is timing. There is really good case law that says that if you go to HR and you report that you think you're being discriminated against, and an investigation is conducted, and then a couple weeks later, a couple months later, you get fired or you get denied a promotion, that is timing evidence that suggests that those two things wouldn't have come in such quick succession if there wasn't a connection between the two of them. So timing is another piece. I usually have my clients make a chronology of events, and I do that because I'm looking for timing evidence, and that's how I can figure it out. What happened first? How many weeks passed? I sent the email, and then 2 days later, this thing happened. That can be helpful. I put it on here because it's so critically important, but you got to tell the truth. That's key. And anyone who might have a legal claim who's early on in their case not telling the truth to you, not telling the truth to their lawyer, it's going to come back. There's just no way around it. And so these experiences are horrific. There's no reason to exaggerate them. There's no reason to lie. In litigation and employment cases, it's really the plaintiff who is the most under scrutiny of anybody. Even though they're the victim, they're the ones that are going to be scrutinized. And anything where you've been dishonest in any way is going to be a real problem. I mean, I've had great cases, and then it turned out one of my clients lied, and I had to let the case go. And it was a great case, and it would have been a perfectly fine case without the lie. But the lie ruined it, and I had to drop it. So there's no need to lie. And then finally, we've talked a little bit about filing a charge of discrimination and trying to find a lawyer. Those are all things that can be extremely helpful that you can do to help your clinic volunteers when they come in. Let me say just a practical reality. You've got 30 minutes, right? And in 30 minutes, how are you going to get through all this stuff and get through it quickly? Well, in your materials, you'll find that I have put together a handy checklist. And this is a checklist that allows you to get a lot of information really quickly and reminds you of what the key questions are. And I would encourage you to use it. I think it's a form that they have available at the clinic. Dominique is nodding her head yes. Okay. So you didn't even have to listen to anything I said or take notes. You could just use this form, and you'd be in good shape. But it is definitely true that you're trying to get a lot of information pretty quickly, because ultimately what you're trying to figure out is this just a standard I don't like my boss kind of situation, or is this truly illegal discrimination and letting people down easy if it is not? The majority of people in the United States, and certainly the majority of people in Washington and the majority of people in the Puget Sound area, are employees at will. That means that they can be fired for any reason, and I mean any reason under the sun. You had a terrible costume that you wore to the Halloween party. I didn't like it. You wore the same costume that I wore to the Halloween party, and I didn't like it. That is a terrible reason to fire someone, but it is 100% legal. You just don't have the right to be treated fairly. The exception to employment at will is if you are terminated or treated in a discriminatory manner because of your sexual orientation, because of your gender expression, because of your age, because of your disability, because of your sex. There are lots of other categories. And your role really is to try to pretty quickly figure out, is this a because of membership in a protected class, or is this not? Much of the time you're going to find that you just don't think there's enough evidence. You're going to suggest to the person that they continue to take notes and continue to think about whether or not they have evidence of discrimination, and that might blossom into something down the road, but they your job is really to kind of be a first gatekeeper and trying to help them come to accept the painful reality, which is employment at will, which is 85–90% of the time, there's not going to be anything you can do as a lawyer, because the world is unfair and it's difficult to prove these cases. But when someone does come forward and they do have evidence that they're being treated differently because of their sexual orientation or because of their gender identity, and you can help them to record their claims, to keep their diaries, to write their confirming emails, to make sure they get into the file a charge with the Human Rights Commission within 6 months, you've really done a tremendous help. You've been a tremendous help to them in helping to do what we're all ultimately trying to do, which is to protect and preserve the right to equal employment in the workplace, and to try to fight against the powers in the world that see us as less than human and see us as less than deserving. And that's an important role that you play as a volunteer. I have time maybe for a question or two, if you've got one. You've got one. I can see it. He's looking around like maybe he doesn't, like maybe I'm looking at someone behind him, but I'm really looking at you. Yeah, any questions?
Me?
Yeah.
No, I thought it was all there.
Oh, okay. Okay, good.
I think you hit every base.
Terrific. Any other questions before I close? Okay. Well, again, thank you so much for your service, and thank you for your vision to build a stronger and more vibrant community of LGBT folks here in the Tacoma area. We think it's wonderful. Thank you.